Okay, so today we're going to evaluate the methods of dispute resolution. The study design requires you to know strengths and weaknesses of dispute resolution methods used by courts and VCAT, including judicial determination, mediation, conciliation, and arbitration. For our purposes, we're going to group mediation, conciliation, and arbitration together and evaluate them as ADR, or alternative methods of dispute resolution. Firstly, to evaluate ADR, we can say that it's much less formal than going to the courts. Because there's no strict rules of evidence and procedure, the parties can sit down in a room with either a mediator, a conciliator, or an arbitrator and discuss their dispute and hopefully come to a resolution. That means that it's far less intimidating for the parties because the focus is on resolving the dispute and moving on with their lives rather than assigning blame to one of the parties. However, if the parties are not of equal bargaining power, then one party may exert influence over the other, or one party may compromise too much, and that can lead to an unfair result. Secondly, ADR is faster and cheaper than litigation due to lower fees and no need for legal representation. That allows more people to have their disputes resolved in a timely manner, and it increases access to the legal system, and it also reduces the burden on the courts as more cases can be resolved through ADR. However, if a decision can't be reached, then the matter may still need to go to court. That increases costs and delays the final resolution. A third strength of ADR is that it's not adversarial. It's a cooperative method of dispute resolution where parties come to an agreement themselves. That means that they're more likely to abide by the decision and they're more likely to be satisfied with the outcome rather than the court system where a decision is imposed on the parties where one party is likely to feel like they've lost. However, as the agreement reached in ADR is not binding except for arbitration, then it can't be ensured that the parties will honour the decision. However, generally parties who go through mediation or conciliation do abide by the decision. Next, to judicial determination. One strength of judicial determination is that it's binding and enforceable. The decision made through judicial determination, whether it's in the courts or VCAT, is binding and enforceable through the courts. However, the decision can be appealed against in judicial determination, which would increase costs and increase the delays involved. And judicial determination is a win-loss situation where one party can feel dissatisfied with the decision. Secondly, judicial determination provides greater formality. Parties often will be more comfortable with that, particularly for more serious cases, particularly for criminal cases. Judicial determination is appropriate for all types of disputes, both criminal and civil cases. However, the strict rules of evidence and procedure can be intimidating for parties, and sometimes they can lead to an unjust outcome. Thirdly, judicial determination provides a great degree of expertise. Judicial officers, judges and lawyers are experienced legal professionals. They have expertise in the law. However, judicial determination is usually far more expensive than ADR due to high court fees and generally the need for legal representation. And that's it.